So a federal court just struck down a state ban on self-manufactured firearms using the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. So let's talk about this. But real quick before we jump into this video, if you believe you have the right to make your own firearms under the Second Amendment, go ahead and hit that like button and subscribe. So like I said in the intro, a federal court just struck down a state ban on self-manufactured firearms using the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. The case we're going to be talking about in this video is Rigby v. Jennings, and it's a decision coming out of a federal court judge, Marilyn Norienka in Delaware. In this decision, she granted a preliminary injunction which bars the state of Delaware from enforcing their restrictions on the possession and manufacture of self-made firearms. This case is a significant win because you have another federal court using the Supreme Court's decision in Bruen to find that a state's gun control law is indeed unconstitutional. Now, some background on this case and what this judge actually did in this case. On October 20th, 2021, the governor of Delaware signed House Bill 125 into law. Specifically, HB 125 criminalizes the possession, manufacture, and distribution of unserialized firearms and unfinished firearms components. This bill made it a felony to knowingly transport, ship, transfer, or sell an unfinished firearm, frame, or receiver unless 1. The person is a federally licensed gun manufacturer or dealer, 2. The name of the manufacturer and individual serial number are conspicuously placed on the unfinished firearm, frame, or receiver in accordance with federal law, and 3. The person maintains records in accordance with the federal law. So HB 125 was kind of your prototypical ban on so-called ghost guns or unfinished frames and receivers, 80%ers, but it also did not grandfather in the possession of those items like you see a lot of other states do. This bill made it unlawful to possess an unfinished firearm, frame, or receiver that does not have the name of the manufacturer and an individual serial number conspicuously placed on a major component of the firearm or of that item. HB 125 also prohibited distributing or manufacturing untraceable firearms, and because of this also went after 3D printers and 3D printed items as well. But banning 80%ers, banning 3D printed firearms was not enough. This bill, HB 125, also went into essentially banning the distribution by any means 3D printed instructions over the internet. These restrictions on the possession, distribution, and manufacturing of these items is what's being challenged in this case. And on review, District Court Judge Marilyn Norienka granted a preliminary injunction in part barring the state of Delaware from enforcing these various sections of HB 125, which restrict the possession and self-manufacturing of these items. And in reaching her decision, she found that the Delaware law does in fact violate the Second Amendment and is not consistent at all with the Supreme Court's recent ruling in Bruen. So first, let's take a look at the possession and self-manufacturing sections and how the judge used the Bruen decision to actually rule on those sections. And then we'll actually talk about the distribution section, which I actually don't hear a lot of people talking about. In the possession section of her order, she stated, turning to the second step in the Bruen analysis, the court finds that the government has not demonstrated that HB 125's restrictions are consistent with the nation's historical tradition of firearms regulation. The government argues that laws tracking and restricting the possession of firearms dates back to the colonial times, and that serialization dates to the same time period as Heller's examples and should also be considered a long-standing and presumptively valid measure. But the state has not identified a single statute or regulation to substantiate its arguments. The judge goes on to state that courts are entitled to decide a case based on the historical record compiled by the parties, and the government has furnished nothing to justify this law as longstanding except for the attorney's arguments. Based on this, the court therefore found that the plaintiffs have demonstrated a likelihood of success on the merits, that the possession sections of HB 125 violate the Second Amendment rights. The judge states that the statute burdens constitutionally protected conduct because possession of firearms and firearms frames and receivers is within the scope of the Second Amendment's right to keep and bear arms, and defendant has not shown these firearms and components are not commonly owned by law-abiding citizens for lawful purposes. Further, the government has offered no evidence that these statutes are consistent with the nation's history of firearms regulation. So there, the judge granted a preliminary injunction against this section of the Delaware law that barred people from possessing self-made and self-manufactured firearms without adhering to the serialization and other requirements under that Delaware HB 125. Then she moved on to the section of the law which bars people from being able to actually self-manufacture these items on their own. In this section, she states, here, the right to keep and bear arms implies a corresponding right to manufacture arms. Indeed, the right to keep and bear arms would be meaningless if no individual or entity could manufacture a firearm. Thus, if possessing untraceable firearms is protected by the Second Amendment, then so too is manufacturing them. She stated, proceeding to Bruen's historical inquiry, the government once again resorts to conclusory arguments and has furnished no evidence that the laws in question are in line with the nation's historical tradition of firearms regulation. It is defendant's burden to justify a Second Amendment burden as longstanding, and the defendant has not put forth any evidence to meet their burden. Accordingly, the court finds that plaintiffs have demonstrated a likelihood of success that the section of HB 125 that prohibits manufacturing untraceable firearms is indeed unconstitutional. So there she found that the right to self-make and self-manufacture firearms and those components is indeed protected by the Second Amendment, and that the government has no historical evidence to support their law, which bans people from engaging in that self-manufacturing conduct. Now, I'm going to cover another section that I see a lot of people omitting, and that really is because this case was not all sunshine and roses. It wasn't just the perfect decision. If anything, I think this judge got it 2/3 right, because she also looked at the section of this law which has restrictions on the distribution / sale of these various unfinished frames and receivers, or so-called ghost guns or 80%ers. On review of this issue, she found that the law permits anyone lawfully able to sell a firearm to do so, and simply requires that those selling or transferring firearms to abide by federal law when doing so. Therefore, she said, plaintiffs will still have access to these components. She said, barring the distribution of untraceable firearms may make purchasing a firearm more inconvenient, but this does not amount to a Second Amendment burden because of the easy access to traceable firearms. Therefore, the court finds that these regulations impose conditions on the sale and transfer of firearms that do not burden plaintiffs' Second Amendment rights, because they do not bar the sale of any type of weapon or impose erroneous regulations on those wishing to distribute / sale unfinished firearms, frames, and receivers. So I'm definitely not a fan of this section of her ruling, because it amounts to her saying and kind of finding that as long as someone can still be able to purchase one of these items, it doesn't matter what restrictions are placed on the sale of those items. So under this section, she did not grant the preliminary injunction for that specific aspect of this law. So theoretically, it's still lawful for the state of Delaware to require that FFLs serialize, run background checks on any of these 80%ers that they sell through an FFL. And then there was another section of this that I didn't really like, and that had to do with her looking at the restriction on 3D printed files, which cannot be distributed or disseminated online. She looked at these First Amendment arguments that were made in regards to this whole 3D printed files restriction, and ultimately she did not grant the injunction against that aspect of HB 125. However, she did not dismiss this aspect of the case like the state of Delaware wanted. They wanted to get rid of this aspect. The judge said that instead these claims were well pleaded. They included strong First Amendment 3D printed kind of claims, and that she would allow for that part of the lawsuit to proceed forward, but she simply is not granting that motion for preliminary injunction. So using Bruen, this federal court judge granted part of the request for a preliminary injunction, striking down the state of Delaware's ban on possession and self-manufacturing of these items. Again, it's a strong step in the right direction. It's not 100% perfect, I wouldn't say, because again, she also said that the state of Delaware's law, which placed restrictions on the sale of these items, was still valid. So she upheld that aspect of it, did not grant a preliminary injunction on that aspect. So that's why she granted the preliminary injunction in part, but it's still a step in the right direction. This is one of those cases that's finally, after Bruen, really helping for all these Second Amendment cases to move in the right direction. And it's just another domino and another case that is now falling the right way. So if you guys have any questions, go ahead and comment down below and I'll try to answer best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.